What's up, guys? Part 2 of Could This Case Get Dismissed Before Trial? From the recent legal filings, let's talk the ultra-critical intel of the motion for Frank's hearing. Is the PC affidavit in jeopardy? And will Judge Hitler order a Frank's hearing? I've got all the details, so let's jump right into it. To properly assess this topic, let's lay out all we know, brick by brick, from the legal filings to date. This motion is under seal and alleges Fourth Amendment constitutional violations of illegal search and seizure. And the underlying premise of Frank's material is that a police officer put false or misleading statements in the affidavit of a search warrant application, or quite simply, a police officer lied in a warrant affidavit. The Kohberger-Franks motion appears to be specific to the probable cause affidavit and warrant used to arrest Mr. Kohberger. And we know this because the Franks hearing verbiage is found specifically in the arrest warrant motion to suppress filing as follows. Quote, the affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. Mr. Kohberger has filed a motion for a Franks hearing that challenges this warrant. So again, just to wrap up on the facts, the Kohberger defense team is asserting that the police officer who wrote the PC affidavit put false or misleading facts in that affidavit whilst omitting material information, including exculpatory evidence, and failed to provide probable cause for the search. So, this rare and serious legal filing obviously begs the question, what story or picture is the defense attempting to paint in the Franks motion to corroborate these claims of false facts in the PC affidavit? We don't factually know because, again, the proffer and exhibits are sealed, but let's examine a couple different scenarios based on what we do already know.
There's no question that motions to suppress are coming. Motions to suppress are coming on warrants. And whether or not those motions to suppress are based on Frank's material because misrepresentations are made depends on the timeline. So if there's a representation made in a warrant that things happened in a certain way, if we are able to look at the timeline and say, we know that the state knew this when, that gives us an answer on whether or not the suppression issue includes a truthful statement in the affidavit.
Story number 1, PC affidavit timeline and federal subpoenas. At the motion to compel hearing in June, Elisa was asking Judge to order the prosecution to turn over the full scope and dates of federal subpoenas in this case to help the defense establish the timeline she is referring to in this segment, something which the prosecution clearly was pushing back on turning over at that hearing. It would be critically important for the defense to have gotten this intel in order to identify any mismatches in timeline between the Fed subpoenas and the PCA to properly challenge the arrest warrant at a Franks hearing. And, as we also now know, the November 14th deadline for filing additional discovery motions has passed. Judge Hitler has denied extending that deadline on the recent defense motion for leave because the defense waited too long to file a motion to request that extension. So if the state never turned over the scope and detail intel on those federal subpoenas pursuant to Judge's order, that tells me it would be unlikely that this is the story or narrative in the current Franks motion, and if it is, it would also make the success rate of a Franks hearing very low. Or could the story be number 2, the PowerPoint, cell, and car visual found in both the second AT&T warrant and PC affidavits versus Cy Ray using his track software to provide exculpatory cellular evidence that directly contradicts this hand-drawn open-source map and also corroborates Brian's alibi defense filings. If you follow me on any of my 4 platforms, then you are intimately familiar with this map and how it has drawn assertions of exculpatory evidence, both on the white sedan CCTV from Ann Taylor and on properly mapping call detail records from Cy Ray. In the potential Franks hearing, is the defense planning to call Cy Ray to provide cellular exculpatory evidence and testimony that it was physically impossible for Brian to have been in Moscow at the time of the homicides per his alibi filings and in direct contradiction to this map? If Cy Ray can prove inside a courtroom that this map used to get the arrest warrant was false and misleading, and Brian was factually miles and miles away from 1122 King, down by that park during the time of the homicides, it would essentially blow up the entire PC affidavit. In my opinion, this would make much more sense as the story or narrative in the Franks motion, and could potentially make the probability of a Franks hearing very